All right, I think we are set up here. Let me mute that. And that. So, I'm here for a hearing on a 9/15/14 motion that counsel for Ms. Robinson and her company Cross and Dot filed as a result of the first version of the complaint that Mr. Folson filed. Hopefully that's what you are here for. I'm assuming you are Mr. Folson?
Yes, sir.
Excellent. And you are counsel for Ms. Robinson and Cross and Dot.
That's correct, Judge. And my associate Margaret Euler is with me as well.
Okay. And could I have your name?
Dylan Wilbanks.
Mr. Wilbanks. All right. We've got everyone we need. So here's what I understand the issue to be. And then Mr. Wilbanks, I'll hear from you or your associate. And then Mr. Folson, of course, I'll hear from you. So we get both sides of it. The original complaint, Mr. Folson sued Ms. Sterling, who was an official at the school where Mr. Folson worked, the schools, Ms. Robinson, Cross and Dot. Cross and Dot was named as a defendant in the style of the case. They were served, they had to answer, but there were no claims made against Cross and Dot. And so that, according to Mr. Wilbanks, is a basis to award the cost to Cross and Dot of having to defend against a complaint that named them but didn't charge them with anything in effect. Ms. Robinson was named in a specific claim, but she wasn't party to the employment contract. And so there isn't a good faith legal argument that she'd be liable for some violation of the employment contract. And I may be simplifying it some, but I'm going to let you amplify on that, Mr. Wilbanks. So the claim as to Cross and Dot is you threw our name in there and you didn't then say we did anything for which we could be legally liable. And then Ms. Robinson, the one thing or the things that Ms. Robinson allegedly did, she couldn't be legally liable for because she wasn't party to the contract. She was a contractor of the school, not an employee of the school, not an employer of Mr. Folson. Mr. Folson has responded in the way he thinks is appropriate and made his arguments, and I'll hear more on those if the sides want to amplify on them. But I guess we have the additional issue that I'd like to discuss. It's not in a motion per se right now, but I dismissed Ms. Robinson and Cross and Dot from the complaint. And one claim survived the various motions to dismiss. It was a claim against Ms. Sterling. Mr. Folson was invited to amplify on it. I think it was a defamation type claim if he wanted to keep it alive. And he did, but in his amended complaint, he added Cross and Dot, or at least Ms. Robinson, back in. I can't remember if he also added Cross and Dot back in, but certainly Ms. Robinson. And so one of the things I need to work through, not in connection with the 9/15/14, but where we go next with this case is, can Mr. Folson do that? He did not file a motion for leave to add parties, which I understand because he wasn't adding a new party. Ms. Robinson had been in the case before, but Ms. Robinson was removed from the case And a plaintiff cannot add a party post-complaint without leave of court. And so it may be that Ms. Robinson, and again, I can't remember if Cross and Dot were re-added as well. They don't really have any answer they need to file, and they can't be in default because Mr. Folson was never authorized to bring them back into the complaint. That's secondary, but don't leave without us talking about that. So let's start with the 9/15/14, Mr. Wilbanks.
Thank you, Your Honor. I think you summarized it very well. And I guess by way of opening, I would say that really my presentation is going to be to present the court an itemized summary. It's not really a summary, it's all the itemization of our billing. And to share with the court, that our billing was reasonable, our rates were reasonable for a case like this.
And your firm, I'm sorry to interrupt, but your firm represented both Ms. Robinson and Cross and Dot throughout the litigation?
That's correct.
Okay.
Yes.
Do you see any issues, probably the wrong word, but in terms of allocating, if I find there is liability, Cross and Dot's argument is different from Ms. Robinson's. And so if your firm, I'm making a number up, billed a total of 100 hours collectively, is it easy to suss out these were Cross and Dot hours versus Robinson hours, or they collectively were your client? And so if you or an associate worked for an hour, you were billing it to that billing code, which is both. Because what if, just say hypothetically, I deny relief for Ms. Robinson? She was sued, and you know what? It was a good faith legal theory. So there are no 9/15/14 fees owed to Ms. Robinson or counsel, but yes to Cross and Dot.
So that's a fair question. Generally, all the pleadings we filed were as to both of them.
Mm-hmm.
And just based on our summary, it would be hard to divide out what went to Cross and Dot and what went to Ms. Robinson. It's a solely owned LLC. She's the only member. There's not a lot of difference between them. And in our office, we didn't treat them as such. But within the case, I understand there's a distinction here.
Sure.
So from my billing summary, it would be difficult. I can tell you, and I'm happy to state this, I'll certainly say it in my place, but I will tell you that the legal issues concerning Cross and Dot thus far have been simpler.
Yes.
Far simpler. So if there were a situation where you said, hey, Cross and Dot's entitled, Heather Robinson's not, a fair division would probably be to say a quarter.
Okay.
The bill will be Cross and Dot, just based on the complexity of its issue versus Ms. Robinson's.
All right. Understood. And we may not need to get into that space. If there's no award, we don't have an issue. If it's an award for both, we don't have an issue. So let's see where we go, but just know that that may be an area we have to explore. Okay.
And with that, Judge, I'll present a summary.
Great.
So
whatever you're going to give me, you've got copies for Mr. Folson?
I do.
Great.
I apologize. I misspelled your name on this. I'm sorry about that. So, Your Honor, this is my testimony portion. I've been an attorney since 2002, and I practiced in Atlanta until 2008. And I've had my own law firm since 2008. Kind of primary areas of practice during my career at different points have been employment discrimination, probably until 2008. And then since then, it's been a pretty heavy civil non-domestic fraud, title issues, property, judgment collection, those types of matters, probate litigation. That's primarily where I've focused. A lot of contract disputes, which this arguably falls under the heading of. Ms.
Are you involved at all with
I know the one you're thinking of.
with
Capochi and Pergola.
Yeah, that I knew we had tackled a few things before. Okay.
We did. That was a fun one.
It's a strange one.
It's one of the stranger ones I've had.
Okay.
So what you're going to see in my summary is that I bill out my time at $400 an hour. Margaret Euler is somebody else who did a lot of work in this case. She graduated law school in 2022.
How do you spell her last name?
Uhler.
Okay.
And her billing rate with my firm is 300 an hour. And then I think I raised that up to 325 an hour at the beginning of 25, or I'm sorry, mid 25. So what you'll see on the billing record is that, you know, the entirety of what we billed, and I actually don't think I have any paralegal time billed here. And in my firm, we regularly bill by the hour and send out bills on a monthly basis. So you will see for each entry what we did, and those entries are made on the dates we do that particular work. And in this case, the work spanned from March of 25 through today, essentially. What you will not see on this billing summary is any work related to having the federal lawsuit dismissed, which we did do. I'll go into that a little bit in my closing, but this is the summary that I've marked as Exhibit 1, and I would move to admit it.
Okay. Mr. Folson, any objection to me admitting into the record for the purposes of this hearing what we'll call defendants 1?
Any objections to what he just stated?
No, you're going to get a chance to give your perspective on things, but he's got that document. You've got it. I don't have it yet. It's the summary of the billings that Mr. Wilbanks has just explained are associated with the work that his firm has done in connection with representing Ms. Robinson and Cross and Dot. And he is tendering that so that I can see what the numbers are and evaluate those. And so my question is, do you have an objection to that being made part of the record?
No.
Okay, great. I will take a copy then, please. Thank you.
And so the amount we're seeking 9/15/14 award for today is $12,517.50.
Okay.
And that is my testimony.
All right. Do you, Mr. Folson, have any questions of Mr. Wilbanks about his qualifications or the billing rates that we've discussed?
I don't have any questions about his qualifications, nor do I have any questions about his billing rates.
Okay, great. All right. Then I think Mr. Wilbanks has presented what he wants to present. Is there anything you want to present?
Yes. I want to first thank you, Your Honor, for this allowing this hearing.
Mm-hmm.
I'm Jeremy Folson. I want to give you a little background of who I am. I was the IT director for the Rice Schools. Prior to that, I was the IT manager for Gwinnett County Public Schools for 7 years. I went to this institution and, you know, it ended up being what it is now. I have a tech background. I have a master's in IT, and I currently teach cybersecurity courses at Gwinnett Tech. I don't have a law degree. I've done a lot of research and a lot of reading to fight on my behalf. And I filed what I filed in good faith, understanding you and your orders, going specifically by the orders that you told me to go by. And so everything that I've done was in good faith based off of what you asked me to do. Since I've been in this situation, due to me being in current litigation, I haven't been able to seek employment for the last 2 years. I'm an IT director, but I haven't been able to find work since then. And so
tell me why that is. Why have you not for a while been able to be employed?
I apply for jobs and then I get the interview, and the interview goes well like it used to before this happened. And then there's no callback, no explanation. Even Gwinnett County Public Schools, that I left there in good faith after working there for 7 years plus. And what they do to me, what's going on is they look, it's searchable. You know, Jeremy Folson, it shows up that I'm in active litigation. And so I just had to, even though I have a master's in several certifications and I still teach part-time, I've had to just do what I need to do to take care of my 4 children who are all under the age of 13. And I've been fighting this without representation as a pro se. And my goal is not to do anything that the court doesn't allow, is to follow your orders. And so when I filed, I specifically focused on my understanding of what your court orders state. And so if I'm a little off in my filings, it's because of my lack of understanding of how the system works, because Heather's attorney has an advantage, you know, because of the background. And even though I do know that you dismissed Heather and Cross and Dot, as well as Rise in your first order, you were kind enough to give me a chance to amend, and I did amend, and you allowed defamation to go forward, even though we're not here for that right now. But the reason I included Heather is because Heather invited me to a meeting to review my contract. She invited me to a meeting to review my contract, and I wasn't able to come because I have a daughter with Down syndrome and she needed to be in the hospital. And so I wasn't available. And when I did get the information, I spoke with Heather about it, and we went from there with it. And so the reason she was brought back up in this situation is because when we got to the point of discovery, I emailed Monica and I asked if it was okay for me to.
Who's Monica?
Monica Niles,
Okay,
your staff attorney.
Ms. Niles.
I emailed her and asked if it was okay for me to go forward with discovery. And she emailed me back and said, yes, this is okay. And so the reason Heather was included, because Lara Sterling was never the one. She's the board chair, but Heather Robinson controlled the contracts. And so Heather Robinson's attorney sent information in discovery. He included the altered contract that was not signed by me. It was missing salary and things of that nature. And so during discovery, I assumed that I had the opportunity to ask for documentation to defend myself. And so I knew Lara didn't have that completely. I knew Heather was the person, because even though Cross and Dot is separate from her individually, they're the same entity. That's her company. She represents Cross and Dot. And so I apologize if I had a lack of understanding, but it's only due to my educational background of me not knowing. And so it was made in good faith. I don't feel like I should be responsible for any attorney's fees. I've been fighting really hard for myself, to advocate for myself, and to get some type of victory in this, because it has affected me greatly. I've never been without a job. I've always worked in higher ed. And when you see these things online about me and I'm involved in active litigation, no one wants to deal with any of that. And so I'm forced to take positions that I'm overqualified for, just to be able to support my family. And including my daughter with disability. And so it's been difficult for me, but I can assure you that everything I've done has been in good faith. To my understanding of the law, being new to this, I've never been in this situation before. And Heather attorneys and Rise attorneys, they have the advantage on me because of their understanding of the law. And so I just appreciate you for giving me this opportunity to be able to talk and explain my side of it. And so I feel like everything I've done was, you gave me an opportunity to amend. And in my opinion, based off of my knowledge, I felt like I needed to include her because she's an important part of the situation when it comes to discovery, right? And so I did, when I sent the discovery information out, I wasn't necessarily asking Heather's attorney to respond to it, but he decided to respond, and he actually presented information that I needed, because Rise was stating that they didn't have the information for discovery, but he sent it from Heather, and demonstrated, and I sent it to you all. I showed a contract that I signed up under my superintendent, and then I showed an alter contract that I had questions about. And when I asked those questions about it, I was pressured to sign. And I said I wanted a meeting. And the next thing I realized, I received an email at 9 o'clock at night saying I was terminated because of me asking questions and not playing a game. And so this is why we're here now.
Talk to me a little bit about why you decided to represent yourself as opposed to hiring counsel, or if that was out of your financial reach, talking to legal aid or some organization that might help you.
In the beginning, I knew it was probably out of my financial reach with me having 4 children, young children. The problem is I reached out to attorneys. I reached out to 7 different attorneys, and no one would take my case. They felt like, being that it is a school, you know, and the sovereign immunity and things that comes with that, it's hard to really win that type of case. So attorneys want something that's solid. You know, they want it to be.
Well, they want some evidence that's going to help them out.
Right. And so I try to provide evidence, but when you're new to this, you know, I understand tech. If you ask me, Your Honor, to build a website or to teach you about cybersecurity and all these different things, or ethical hacking, that's what I know.
That's your space.
Right. But in this space, I've had to do a lot of reading and research.
So an interesting confluence of what you're calling your space, and we'll call it the legal space, is relying on AI to help with legal briefs. And I'm curious, when you submit a brief and sign it, say, this is my position, you are, as is Mr. Wilbanks, it's nothing unique to Mr. Folson or a pro se litigant, but anyone who submits something to the court, you sign it, you are saying the stuff above my signature is true and correct. And so if I'm citing to a case, I know that case exists and that case stands for that proposition. So if I cite a case like Kravitz versus Georgia Realty, number 1, that's a real case. And number 2, if you, judge, go read that case, it's going to say, in effect, Folson's right and Wilbanks is wrong. I'd like you to share with me how you navigated the process of relying on AI as a legal partner, but making sure that what you filed wasn't going to be potentially misleading because your motion or your brief cites to a case and maybe there's no such case.
Right. I appreciate that question. And AI is something, even though it's been around for a few years, it's still relatively new. And so as a cybersecurity professor, I'm not going to rely on AI because I know that I should take AI with a grain of salt. And so when I do dive into that space of AI, I understand it as a grain of salt. So I do additional research. I do additional, you know, I'm trying to train myself to be an attorney as a pro se to fight for my rights. What happened to me, me never being unemployed, me having an impeccable background, me working for the biggest school district in Georgia for 7 years plus with no issues. I took a chance on Rise to embed the community, to bring my knowledge to that institution. I never worked for a charter school before, so I didn't know the dynamics of, okay, what goes on. And so when I got there and started exposing some things that was going on financially, I became an enemy. And the person that was protecting me, which is my superintendent, they terminated her and I was next. And so I was forced and pressured over and over to sign a fraudulent contract. And I told Heather and I told Lara, I said, I need to have a meeting to discuss this. And they ignored me and they said, you sign it or else. And I said, I won't sign it until I have a meeting. And when I get home, after I pick my disabled daughter up, I come home to an email that stated that you've been terminated without any type of reason. And I still didn't understand the email. And I went to work regardless, seeking Heather, trying to find out some information from her. And I worked the whole day. And I still didn't know if I was terminated or not because I was having meetings as usual. And it was just the weirdest thing to me. And so what I'm telling you today is I go by what you tell me to when it comes to my understanding. It's not AI, it's not whatever. It's me making a real good faith effort to do exactly what the judge tells me that I am able to do. And I don't want to be taken advantage of for my lack of knowledge when it comes to this. Not talking about Mr. Wilbanks, but he's an attorney. He's a smart attorney. He's used to this. I'm not in courts. I'm in computer rooms. I'm providing support. I'm teaching and mentoring, right? So this is a foreign space to me, and I'm trying to do the best I can with the limited knowledge that I have regarding how this works. And so, again, it was made in good faith. Whatever errors was made on my behalf, I do apologize, but it was made in good faith, and I feel like I shouldn't be responsible for attorney fees, $12,000 plus, and when I'm already struggling financially to support my family. It's shameful. It's hurtful to me that this is even a situation.
Okay. Well, I appreciate that perspective. I think it's important for you to understand, and you probably understand if I'm going to share it, a few other things to keep in mind as you're balancing all of this. It is not good for business for Cross and Dot to be sued. Someone can go online and say, what's Cross and Dot? Look at that, they're being sued. I don't think I want to have them as my business partner. Why are they being sued? And if they were being sued wrongfully, not meaning that you were out to get them, but because you didn't know better, because you chose not to hire an attorney and you threw their name in there, I, as a potential business partner of Cross and Dot, have no way of knowing, it was a rookie mistake by a non-lawyer. So there are costs and consequences to the decisions you made, even if they were made in good faith. And so the system is designed to weigh that as well. I don't come into this thinking that you had a vendetta and you're dragging everyone in, and you would have named more people in the lawsuit. Because we get pro se litigants who just look for every name on the distribution list and I'm going to sue all these people. And then they start suing the judges as well. We see it real quickly. I didn't like that ruling, and now I'm adding Judge so-and-so to this lawsuit. And then we amongst ourselves realize we got to wall this person off, because every time they hear the word no, then they're going to sue that judge as well. And that ends very poorly for that litigant. And I'm not putting you in that category. No. But there is a very real consequence for the people on the other side of the V. You mentioned that people look you up online and they see you're in active litigation. They're all lawsuits that you initiated. Not that you shouldn't have, but of course you started them.
Yes.
The people on the other side may have done things that in your mind merit being sued, but they didn't start that litigation. Mm-hmm. They have made decisions that I better get a lawyer. First of all, an LLC cannot represent itself. So Cross and Dot being sued, if they want any legal protection at all, they have to hire someone. Ms. Robinson could have decided to represent herself, and then it's pro se versus pro se. Those are always entertaining for a judge. But Ms. Robinson didn't. She hired counsel, and so it was for Robinson and Cross and Dot. But the moment you name Cross and Dot as a defendant, there are public relations issues for that entity because of the digital world we have today.
Yes.
And there is a legal expense because they cannot file an answer without having an attorney. They have to pay someone to file that answer.
Right. I do have something I want to add.
Okay.
And maybe you're aware of it already, but it's a parallel lawsuit. I have a federal and state, right? And so the EEOC investigated thoroughly when it comes to my ADA rights, and they agreed with me and provided me with a right to sue letter regarding Cross and Dot and Heather. And so that case is still active and pending.
Wilbanks said he was going to talk about that too, so it's good you're talking about it. But right. Of course, that's not a state court lawsuit.
Right, and I know in this, what I want to say to you personally, I appreciate the process in all of this. Me learning, me understanding things that I didn't know before. it makes me appreciate what you do and what he do even more so, because I understand. I feel like it's a course that I've been in, fighting this lawsuit. And yeah, I'm struggling financially, but I am being an advocate for myself and my family. I know what happened to me shouldn't have happened. And I understand what you said about crossing out instances, but the way I look at it, dealing with Heather while I was there, in the way she said, you need to come to me to sign this contract. And I told her my daughter had to go to the hospital, right? It was a conversation and I wasn't there for it. But when I did speak with her, I told her, I said, Heather, why is my salary not shown on this? And so going back to discovery that was allowed, I emailed Miss Monica Niles and I said, okay, Miss Niles, I read the judge's order, but I want to make sure that I go by what the judge is telling me. And I want to make sure I understand, since I have a lack of education when it comes to being an attorney. And she emailed me back and she told me, she said, you have every right to go into discovery. Discovery closed at this time. And so this is what brought Heather and Cross Knot back into the picture. It was me knowing that Heather was the HR consultant and she had that information. If you look at the discovery input from Rise and from Heather, you will see that Rise mentioned that they didn't really have anything, but Mr. Wilbanks was nice enough to send me the information that I was seeking, which was the Ultra contract, which was the basis of why this all started. Even though that was dismissed, he think that even though you told him that it was already dismissed. And so even he had understanding that they were out of the case, but he volunteered that information. And I'm thankful that he did, right? And I included that in my motion to compel, and you responded to that already, right? And so what I'm asking for is some understanding of me being a proxy and me trying my best to meet deadlines, to make sure that whatever you tell me in your order, we execute.
Great. Well, I appreciate that. The other thing I had wanted to mention, besides the impact that bringing a lawsuit has on the people on the other side of that lawsuit, is a partial response to your observation that you've made several times, that you're just a pro se litigant, you're new to this, you don't know all the rules, et cetera. And I agree with all that, and I appreciate that. That gives you some leeway, especially when it comes to filing a complaint and trying to articulate what your claim is. It's one of the reasons why the defamation claim wasn't dismissed, that you were given a chance to flesh it out a little bit more. But the law is also clear that pro se litigants are still governed by all the same rules and regulations. There's not the easy set of rules for someone without a lawyer and a complicated set of rules for someone with a lawyer. One set, and it applies to everyone. So rules that prohibit someone from bringing a lawsuit against a party, just naming them in the lawsuit, but then not making any claims against them, that applies just as much to Mr. Wilbanks if he did it as it does to you. That may seem a little unfair to you because you'd say, well, how was I supposed to know that? And one answer is, well, it's out there. I mean, it's not hidden. It's in a law book. It's in a statute somewhere. I don't assume you know it. I don't assume that all the lawyers know it, but there's a way to research it. And it's one reason why people decide in the end to get a lawyer, so you can avoid hitting some of the potholes that are out there.
Right.
And a good lawyer is swerving left and right because there's a legal pothole, but here's something you can do to not crash your car right there.
Yes.
And you, because you're very intelligent and learned in other spaces, you're kind of driving like you have an eye patch on one eye and your other eye is a little blurry because it's just new territory for you. And so you are bound to hit some of those potholes that a lawyer would know or be able to see and say, I'm going to turn to the left so we don't hit that pothole. And that's just the unfortunate reality. You know, people like to say, lawyers, what do we need lawyers for? You are coming to experience what we need lawyers for.
Right.
We don't need them to wash our dishes or to bake a cake. They're probably bad at both those things. But when it comes to filing a lawsuit that doesn't blow up in your face, a lawyer can be a helpful partner in that process.
And I begged, I can send you emails.
I sent
begged-
7 lawyers and they said, no, thank you.
I didn't understand why they didn't want to take the case. I knew I was done wrong because I told one attorney, I said, I signed the contract when the superintendent was there and they got rid of her and they wanted me to sign an alternate contract. And I sent him the contract and he said that he wasn't able to take my case. Yep. And then I called the next one. And the next one I said, okay, something needs to be done about this because all I brought, like I shared with Lara, you know, one of the first projects that I was able to complete once I got there was a network and infrastructure project where I saved the school district $160,000. And my heart was in it. My heart was in it. I still don't understand what happened. All I can do is, you know, I didn't want to represent myself. I wanted an attorney. But they wouldn't take my case. And it really wasn't explained to me why. Mm-hmm. So I'm a Scorpio personality. I'm a fighter. I'm an advocate. I'm used to being an advocate for my children, my daughter with Down syndrome, fighting for her IEPs, making sure, you know, I'm checking with the teachers and the counselors and making sure she's getting the support that she needs. And so I'm used to being an advocate. Never did I want to disrespect the court. Never did I want to do something that wasn't allowed. Based off of my understanding of your order, I assumed that it was accurate. I assumed that everything that I've done based off of my research, because I'm not the type that, oh, I'm going to type this up and send this. No, I researched hours spent. He mentioned attorney fees. I don't have an attorney, so I can't say that. But if you knew the amount of time that I put into this, hours on top of hours, learning. My background is information technology. Me learning Heather's lawyer and Lyra's lawyer, just putting so much time in. My spouse asked me, she said, are you do you need to take a break from this? I said, I can't. I mean, I'm an advocate for myself. I have to at least fight. I have to at least fight. And so I don't understand why Mr. Wilbanks, I don't understand why we're here now asking for attorney fees. I'm already struggling as it is for being out of work for 2 years for the first time in my life. With me being a sole provider for my family, me not understanding how mortgage is going to be paid continuously, and me needing to pay my car note and other things that I have going on. And so I'm still pushing because I know they look me up when I'm applying. I know what's going on with this, but these attorney fees, $12,000 on top of what I'm dealing with, it's crazy. To me, it's crazy. But trust and believe, I didn't come into this wanting to represent myself. I just didn't get the help that I need. I can literally show emails of me begging, like, could you please just like look at this? Could you look at that? And it was such a dismissal. And that's when I realized I'm not going to receive any help. I have to represent myself to the best of my ability, understanding that I have that right, understanding that you are the judge, you have your orders, you're clearing your orders. It's just that it wasn't willful ignorance on my part. It's just a lack of understanding of the procedures. And so I feel like I deserve some type of grace as a proceed, even though you have the law, you have procedures. But if you look at the history of this case and what I've done and not done, I've tried my best to meet deadlines. I tried my best to do what I need to do, so you can have what you need to make an informed decision.
Okay, well, I appreciate that. And I have no doubt you've worked very hard at this. It's got to take you more time to do step one than a lawyer who's done step one
Sure.
100 times before. So you're learning a lot. Maybe you now want to go to law school.
I do, to be honest with you.
Good. Well,
I told my friend, I said, you know what? I think even though I'm in IT, I have a master's in it, and I currently teach at Gwinnett Tech. I love teaching. I teach part-time there, but it's like learning about this process and understanding it. I said, you know what? I should have been an attorney.
well, it's never too late. Let me hear from Mr. Wilbanks. I know he wanted to present a closing since he's the movant. So I would like to hear from you, Mr. Wilbanks, if there's anything you think needs to be added.
I appreciate that, Judge. I won't go on very long here. As Mr. Folson was talking, I was kind of reminded of a story that our pastor told maybe annually, about a flood and a guy whose house the water was rising and somebody comes by in a rowboat and the guy's like, no, I don't need your help. God's going to save me. Goes up to the second floor. There's a bigger boat. No thanks. God's going to save me. He's on the roof. Helicopter comes by. God's going to save me. Obviously he drowns. And he gets to the pearly gates. He's like, I thought you were going to save me. And St. Peter says, we sent you 2 boats and a helicopter, man. When you talk to 7 attorneys and they say, this is too hard, to me, that's the sign. And I have no doubt. I have no doubt about your good faith. None whatsoever. And this isn't to attack him, but part of the 915-14 statute that I think is important here, and it's under subsection A, is there's got to be reasonable belief. I don't think with what he filed, I see evidence of necessarily a reasonable belief that what he was doing should have been done. And as you said, judges and attorneys kind of have an understanding about pro se people. That's why when he wants discovery, I'm not going to stand on formality. I'm not going to make him send me a formal third-party request. I'm just going to send him the documents because he can get them. I'm not going to make his life more difficult. I'm not going to make my life more difficult. But at the same time, we didn't file this motion until he tried to add us back in this case, somewhat informally. And there's also the federal case. And really, when I'm talking about reasonableness, to me, that's the best evidence. And he talks about the federal case as though it's a plus. It supports his position here, where every attorney knows you don't sue somebody for the same thing in 2 different courts. That's a very basic thing. I have a lot of respect for IT professionals, and that's a reason I would never try and be my own IT professional because of what an expensive problem I can create. And however sympathetic Mr. Folson is, Heather Robinson's sympathetic. She's a nice lady. She's a single mom, 1 in college, 1 on the way to college. And I think you correctly pointed out that the implications for her was, yeah, she's got a business. She didn't want to default. She didn't have a choice. She didn't have the option to do the many hours of homework Mr. Folson did. She didn't have a choice but to cut that check. So for those reasons, I doubt there's anything I can tell you about subsection A or B that you haven't heard a million times before, and you kind of know these when you see them. This is a motion that I filed that is almost just as much about deterring future attempts to get Ms. Robinson into a suit where she doesn't belong. And if you look at that EEOC letter that he shared with us several times, it doesn't say that he has a claim against anybody, but especially not Ms. Robinson and Cross and Dot. What it says is we have 180 days to investigate this. I don't think it uses the words we're not going to finish, but it says we're giving you your rights back. And, as attorneys, we have the benefit of knowing that when the EEOC loves a discrimination case, they take it on. Kudos to him for even knowing to go to the EEOC.
I get lots of cases where someone didn't get the right to sue, and then there's the immediate defense. Like, look, they didn't even get a green light from the EEOC. So further proof of Mr. Folk, the depth of his homework.
Absolutely diligent. Absolutely diligent. So I appreciate your time here. I would ask the court to grant our motion as to both Robinson and Cross and Dot in the full amount we sought. And I will reiterate, none of that includes what it cost her work to get the federal case dismissed. Thank you, Judge.
You're welcome. So I will take this under advisement. I appreciate, Mr. Folson, your time, and Mr. Wilbanks, your time, and Ms. Euler's time. I'll get an order out soon-ish. In the meantime, the rest of the case keeps motoring along, and we'll do what's appropriate in that part. Mr. Folson, any questions about what's coming next?
Yes, and I have questions. I also want to add to, if that's okay, what he just mentioned.
Okay, if it's brief, you can add to it.
I will keep it brief because being a professor, I talk a lot for 3 hours every Tuesday and Thursday.
Okay, we don't have 3 hours, so.
We have 2 seconds. And so my thing is, he had mentioned earlier that the federal is parallel to this case. The federal includes the ADA of them denying me my accommodations for my daughters with Down syndrome. So the EEOC investigated thoroughly and they provided a right to sue letter. I'm not able to sue federally without that letter. So they did investigate, they did ask questions, and it's very noticeable what happened in regards to that. And so I just wanted to add that to it.
Okay, understood. And then you said you had questions?
I have questions about what happens next. And so I know the first complaint, you told me to be specific about Lyra, right? Then you gave me an opportunity to amend. I amended that complaint. I included additional information such as the police report and agreements from my tech and other things that prove that it was defamation of character. And so Mr. Wilbanks, from my understanding, only filed a motion after discovery. And even in discovery, I requested information, but I didn't necessarily assume that he would respond or not. But he did respond with HR documentation that Rise stated they did not have. Only Heather Robinson had the documentation. And she is the one who sent me the contract. He sent me the altered contract on her behalf. Contract that's different from what I signed legally under the superintendent at the time. This contract lists Lara Sterling, a board chair member, as the governing authority, and it lists no salary for me. And so I had questions about it before I signed because I didn't want to sign a contract and I didn't know my salary. And I feel like anybody would have questions. And so I just wanted to add that to it. Like I said, everything I've done has been in good faith. It hasn't been to harass or cause an annoyance or, aggravate anybody. I'm a professional, and even though Mr. Wilbanks is supporting Heather and representing Heather, I respect his position. I respect Heather's position. I understand that we are in the court of law. And so as an advocate for myself, I'm here to represent myself after being denied by attorneys. And maybe I was denied because I didn't represent myself well enough to them. But I've gotten this far by the grace of God, and I hope that you see my perspective in this and in regards to me showing good faith effort.
Okay, I do. And in terms of what's next, I was just reviewing the order that I entered about 2 weeks ago. And we're back to where we were. Count one remains, that's defamation. So Sterling is still in as a defendant, and the claim against her is defamation. Rise is out again, and I'm going to deal with the status of Cross and Dot and Ms. Robinson as part of my ruling on this motion for attorney's fees. And that's it. Your motion to compel was denied, and there's not a default here. So we're moving forward in that way. Okay.
Okay. My next question, if you don't mind, how does this look going forward? I know you have your calendar and you're working on things, but with me not completely understanding what's next, I just wanted to see if you can provide some additional feedback.
I'm just looking to see if there is a scheduling order for this sort of second iteration.
And I do want to add while you're searching, I did receive an offer to settle from Rise that I declined.
Okay. I will have to ponder what's next. We never did a scheduling order, I think, because there were motions to dismiss pending and you amended the complaint. So I think right now it's just sort of discovery is happening. I think technically probably the discovery period has closed, but that's an issue for Ms. Sterling and you to be discussing and not anyone else.
Mm-hmm. They told me that they have nothing, no more to send me, and it's closed per your order that you said.
Okay. Well, I'll look more on that and then we'll figure out. I mean, what would be next would be trial. So we'll see where we head with that. Okay.
Thank you.
All right. Thanks everyone for your time.